Good afternoon, everyone. I am going to call State of Wisconsin versus Amanda Chapin, case number 22 CF 136. Can I have the appearances, please?
State appears by Attorney Corinne Frutiger.
Amanda Chapin appears in person and with her attorney, Morgan Johanning.
All right, and we are present in court today for purposes of the sentencing. Are we ready to proceed?
Believe so.
Yes, Your Honor.
I've had an opportunity to review the pre-sentence investigation that has been prepared, as well as the other victim impact statements and information that has been filed with the court, as well as reviewing the entire court record. As it relates to the pre-sentence investigation, are there any additions or corrections from the state?
No.
From the defense?
A few, Your Honor. On page 1, defense attorney is listed as Morgan Sauter. That is my maiden name. It should read Morgan Johanning, Johanning. And at the time this report was prepared, the answer to the question of under other considerations on page 1 was, is she currently on supervision? Yes, but she is off as of today.
She's completed her supervision? Okay.
That's correct, yes. And the other inconsistencies were inconsistencies of statement, which don't need to be discussed.
All right. So as I have indicated, I have had an opportunity to review that. I do believe that the pre-sentence investigation writer is on Zoom. I'm sorry, what, Sally? Okay. Move the... I'm sorry, just a second. Does that help? Okay. So, as I said, I've had an opportunity to review the pre-sentence investigation report. The writer is present via Zoom. And I would note that the recommendation that is coming from the pre-sentence investigation writer is a total sentence of 6 years, 3 years of initial confinement, 3 years of extended supervision. The maximum penalty the court could impose for this crime would be 12.5 years, 7.5 years of initial confinement, 5 years of extended supervision, and or a $25,000 fine. So that is sort of the parameters that the court is looking at this point after accepting the plea and entering judgment on that previously. I note that there are people that are present in the courtroom. Ms. Frutiger, do we anticipate that there are going to be any people, either the victim or anyone from the victim's family, that is going to be speaking today?
No, they want to rely on their written statements to the court.
Okay, that's absolutely fine. As I said, I've had an opportunity to review not only the pre-sentence investigation, but then also the written documents that were filed with the court. I believe it was yesterday I had a chance to review those. So. I will then be referring just to victim, and then I don't think I've had it written out any place, but I will not be using the name at this point. And then, do you have anyone that is going to be making any statements on behalf of the defendant?
No, Your Honor.
Okay, so, Ms. Frutiger.
Thank you, Judge. I'm going to start by repeating, I suppose, a little bit of the information that the court just talked about. Today, the state is asking that the court sentence the defendant to 10 years in the Wisconsin state prison system, which would consist of a sentence of 5 years of initial confinement and 5 years of extended supervision. The PSI is, of course, recommending a 6-year sentence consisting of 3 years initial confinement and 3 years of extended supervision. I can only guess at what I think the defendant's argument will be to the court today, but based upon her statements contained in the pre-sentence investigation, I'm going to assume that she's going to be requesting some level of probation or some very minimal level of incarceration. And I think she wants the court to do that on the basis, again, I'm saying this on my reading of the pre-sentence investigation, but she's asking the court to grant a minimal level of incarceration or a probation sentence, essentially on the basis that she's a good person, and the fact that she maintains her innocence throughout the PSI. But we're not here to decide a sentence based on whether she's a good person, whether she's a bad person. We're here to decide a sentence based upon the crime that she committed. first-degree recklessly endangering safety, meaning that she engaged in behavior that showed utter disregard for human life. Despite the statements to the contrary that are contained in the PSI, what we all know based on sitting before the court today for a sentencing hearing is that the defendant is guilty. She entered that no contest plea. She agreed to the facts stated in the criminal complaint. She agreed that they are substantially accurate. And just like we would in any other case, we're looking at the three primary sentencing factors. We're looking at the gravity of the offense, the need for the protection of the public, and the need for the rehabilitation of the defendant. In the state's mind, the rehabilitative needs of the defendant are low. She's not a drug addict. She doesn't require substantial treatment. There might be mental health treatment that she needs, but they didn't come across strongly in the PSI. The only area that came across strongly was the need for essentially anger management treatment. The need for the protection of the public, I would argue, when we're talking about maybe the general public, is relatively low. But the need for the protection of the victim and the victim's family is certainly very high. So it's specific protection of the public that we're talking about in this case. No, we should be good because we have a steno here that we don't. No, that's okay. Sorry, Judge, there was just conversation that normally our DAR system is recording, so normally we see the clock and the clock is not on, so we thought maybe we were having an issue with the record, that's all.
I have an old-fashioned steno reporter. Actually, she's not an old-fashioned steno reporter. She's probably one of the more technically savvy steno reporters because I have real time, so go ahead.
Oh, perfect.
Sorry for the interruption.
No, that's okay.
And Judge, the last sentencing factor is, as we know, it's the gravity of the offense. And that's what carries the most weight in this case. The court already said it. We're talking about a maximum possible sentence of 12.5 years, 7.5 years initial confinement, 5 years of extended supervision. And in this case, we're talking about a number of aggravating factors. And I think what's important is that we review some of that. So ultimately, right, reviewing the history of this case, what we have is that in August of 2021, the victim and the defendant met online very quickly. Their relationship progressed. They moved in together. They're married in March of 2022. By the following month after getting married, in April of 2022, the defendant is writing in journals about wanting financial independence and about opening a yoga studio in Hawaii. And there are already emails from the defendant and the victim showing that there's already strife within their marriage. In May of 2022, the defendant becomes the power of attorney for the victim. In June of 2022, there's a quitclaim deed signed that gives the property to the defendant if the victim were to pass away. In July, on one occasion, July 18th of 2022, we have the victim becoming ill, going to the hospital on July 21st of 2022 with an unknown condition. He was feeling dizzy, lightheaded, something was obviously wrong. They just couldn't tell what at the moment. July 23rd, 2022, the victim tells his family this marriage is over. The defendant sees those messages because she routinely goes through his phone and reads his conversations. July 30th of 2022, the defendant is emailing directly and receiving emails about properties for sale in Hawaii. August 2nd of 2022, the victim drinks coffee prepared by the defendant like normal and standing up. It's similar symptoms to July 18th. On August 5th of 2022, the defendant helped the victim euthanize the defendant's dog using the euthanasia drugs that the victim kept at home because the victim had been a vet, right? That was his profession. That's what he knew to do and how to do it. August 7th through the 14th, the victim and the defendant go to Canada to visit the defendant's sister. Immediately upon return, the defendant is researching cheap flights to get away from the area. On August 16th, the defendant is emailing the victim about their marriage and about the struggle and tension in their marriage. On August 20th, the defendant is searching how to delete internet history and even watches a video on how to do it. And it's the events of August 21st that bring us here today. 8:55 that morning, we know that the defendant logged into the victim's email and was forwarding emails to herself that the victim had received from his children. 8:30 to 9:30 a.m., the victim is sitting outside, drinking his coffee that the defendant had made for him, again, like normal. The victim tells us in the PSI that he never stays outside past 10 a.m. because where they sit outside to drink their coffee in the morning gets baked in sunlight and it gets too hot. So by 10 a.m., he's always coming back inside. By 10:28 a.m., the defendant is having a video chat with a group on a WhatsApp for 20 minutes or so. At 12:08 p.m., the defendant goes into the victim's email again and authors an email to the victim's child or daughter saying, essentially, "Good job, you've destroyed my marriage. You're the cause, you've ruined it." At 12:28 p.m., the defendant is calling 911, claiming to have found the victim unresponsive and claiming that he's been unresponsive for 10 minutes. She claims that she had been in the shower. It's also, I think, noteworthy that he has supposedly been sitting outside for 3 hours drinking a single cup of coffee, while according to the defendant, she's off feeding dogs, taking showers, doing things about the home. Eventually, the victim is taken to the hospital, they run testing, and what we find is barbiturates in his system. And what poison control tells us is that there's never a normal amount of barbiturates to be found in someone's system. They simply shouldn't be in your system, period. And what's also in his system is a euthanasia drug that the victim knows is a euthanasia drug because it's the same drug that he had used to euthanize the defendant's dog only weeks before. Again, following this incident, August 23rd and 24th of 22, the defendant is sending the victim's emails to herself from his account. She's logged into his account. She is sending these emails, including emails from his attorney about a marital property agreement. She's photographing the contents of his phone and sending them to some unknown person on WhatsApp. By August 26th, the victim has minimally recovered enough to return home, and the defendant leaves. By August 28th, she's emailing to the victim, claiming that she's committing suicide, sends that message on September 1st, and then she's found unresponsive after taking some Benadryl. That's the central timeline of events that we have here, Judge. First-degree recklessly endangering safety, as I said before, and as we know, is a crime that requires that somebody engages in a behavior that shows utter disregard for human life. That means you engage in behavior and have no thought given, no care whatsoever to what might happen to another person. And that is minimally what the defendant did here. giving a person coffee laced with barbiturates and euthanasia drugs, and then leaving them for hours, never checking on them, never seeing what might have happened if they drank that coffee that you put barbiturates and euthanasia drugs into, that's showing utter disregard for someone's life. She attempts to disguise that 3 or so hour period where the victim is, in her mind, just sitting quietly enjoying his coffee on the porch, well past the 10 o'clock hour when he normally returns inside, as she's just busy doing stuff inside the house. She's feeding the dog, she's watering the dog, she's taking a shower, she's cleaning up. But I caution the court to believe that version of events. It's nothing short, in the state's mind, of disingenuous. Because what we all know from our own real-life personal experiences is that we know the regular habits and behaviors of our partners, our husbands, our wives. I know that when I return home every day from work at 5:30, 6 o'clock at night, and my husband's not at home, I know he's probably at the gym, and I know that if he's not home by 7 o'clock, that means he's doing something that I don't know about for once, and so I have to call to say, where are you? Because now I'm worried, because you're not home when you would normally be home. I know, in my experience, that sitting at home on the couch at night, my husband is sitting on a couch and has his eyes closed, and I say, are you sleeping? And he says, no. I know he's sleeping, right? And I know he's always going to tell me no. And these are sort of silly examples a little bit, maybe. But it's a direct point of saying we know what our partners are doing. We know, and the defendant would know, by being in a relationship with the victim, by living together, by engaging in this activity that they did every day, essentially, having coffee out on their porch every morning, that the victim was not sitting outside well past 10 a.m., well past noon, enjoying a single cup of coffee. There was reason for her to be concerned. There was reason for her to have gone and looked out a window, looked out the door, popped her head outside to see, what are you still doing out here? The act of not returning outside is nothing short of an attempt to allow the barbiturates and euthanasia drugs that she had put into the coffee to take some kind of effect, to accomplish something. One can only think that the only thing that lacing a drink with barbiturates and euthanasia drugs would do is kill a person or minimally, substantially impair that person. So when we are looking at our sentencing factors, when we look at the gravity of the offense, when we talk about the fact that putting drugs into someone's coffee clearly endangers their life, I don't think it's reasonable that the court would put the defendant on probation. I don't think it's reasonable that the court would assign a relatively low level of prison that's recommended in the PSI, the 3 and 3, for the total of 6 years. The gravity of the offense warrants a significant punishment. It warrants what the state is requesting, the 5 years of initial confinement followed by the 5 years of extended supervision, even though she doesn't have a criminal record outside of this, or excuse me, a lengthy criminal record. She does have the one conviction already. Ultimately, what I'm asking the court is to look at the timeline, to consider the timeline of events, and to consider the defendant's intentions. She knew what she was doing, and her motives seemed clear. She wanted financial independence. She was looking how to delete her history telling us she was looking for a way to ensure that nobody finds out what she's up to, coupled with forwarding these odd emails from the victim's account to hers, this 3-hour or more window where she leaves the victim outside. All of that taken together tells the court the significant nature of the crime the defendant committed here, the aggravated nature of the crime committed. And in considering that, I believe the court can and should impose the sentence recommended by the state, the 5 years incarceration followed by the 5 years of supervision. Thank you, Judge.
All right. Mr. Henning.
Yes, thank you. I have to disagree with the state. I do believe that whether someone is a good person or not is relevant to how the court should rule, because a number of things about how someone conducts themselves in their daily life for 5 decades should be a contributing factor to what the sentencing is. Amanda Chapin has had a lifelong track record of being a rule-following, law-abiding citizen until she met the victim, her husband, and his family. She comes from a good family and was raised with faith. Neither her parents nor any of her siblings have ever had any trouble with the law, and Amanda has lived a pro-social life since childhood. As a child, Amanda was a whiz kid who got good grades and did well in spelling bees. She was a rule follower who was never suspended or expelled. She had structure and responsibility from her parents, which, if not respected, provided her appropriate consequences. She learned right from wrong from her parents and from her exposure to faith and the stories in the Bible, which she carries with her into adulthood. As a young adult in college, she would spend her lunch breaks at the school for the intellectually disabled children. Her childhood and young adult years in Trinidad were peaceful and provided her with a good foundation for the woman she has become. That is, a woman who has dedicated her every career path she has ever taken to helping others. She has been a medical coordinator who helps people find the right kind of care. She has been a yoga instructor who helps others with movement and fitness when she discovered how amazing movement was for her body after a near-fatal accident as a young adult in 1987. She provides care and love and support to her 40-year-old nephew who has disabilities following an accident in his adulthood. She has worked for various ministries over the years in both paid and unpaid positions. At one such ministry, her boss was diagnosed with cancer, and it was Amanda who took him to his chemotherapy appointments and visited him when he was recovering in a nursing home. Amanda is a woman of service in her chosen work and in her free time. She is always very active in her churches wherever she lives. She volunteers and makes friends because she is warm and kind and selfless. Even after these allegations of her having poisoned her ex-husband, her congregation stood behind her because they knew her. They continued to welcome her to services and thanked her for her volunteer work with them. They also allowed her to prepare food for the children at Vacation Bible School. Her own Reverend Meyer, said that he never believed she was a menace to society. He describes her as intelligent, dignified, productive, and hardworking. He told the PSI writer that she had only ever sought of him spiritual guidance and that she did not harbor hate or negative feelings towards Gary and his family. The whirlwind romance that was Amanda and her ex-husband was them meeting on a dating app, dating for a short while, becoming engaged and getting married in relatively short order. They were both head over heels in love, despite what it sounds like when you read the victim impact statements. There was not as much animosity towards Amanda as the family would have the court believe. The mother of the victim's children and his ex-wife of 25 years, had a very deeply rooted relationship in the victim's life and in the life of their children. Those roots were not disrupted when the victim started dating again after the divorce. She had been a persistent presence in his life for 25 years, and to this day, she claims to know how much Gary's assets are worth, what he has in the bank, or even what he has in the medicine cabinet in his bathroom. Amanda accepted this bond between the two of them, in part because she had a similar healthy relationship with her ex-husband of 12 years, and Amanda worked to cultivate her own bond with her husband's ex-wife and children. The family was hesitant to accept other girlfriends that the victim brought around and gave Amanda some of that same grief at first. However, the love between the victim and Amanda persevered, and Amanda did develop a good relationship with the victim's children. She baked them zucchini bread and visited with them often. She was very close to the victim's beloved aunt, who even attended and blessed their courthouse wedding ceremony. Before meeting the victim, Amanda never wanted for a job or housing security. The family she grew up in was more financially comfortable than most, and it would simply be untrue to imply that the marriage between Amanda and the victim was based on financial motivations rather than love. When some conflict arose between his children and Amanda, it was the defendant who defended her. Over the past year and a half that this case has been pending, Amanda has continued to work and continued to support herself. When the victim, in his 70s, started to show age by slowing down, Amanda and his family noticed. When he started experimenting with self-medicating for COVID, using veterinarian medications and protocols that he was thinking up with other professionals, Amanda was worried. Amanda even asked the victim's son to spend some time around him to evaluate his dad. The victim's son admitted after watching a round of golf with his dad that his dad was slower and more lethargic. There was a time when Amanda was sure that her husband was having a stroke and urged him strongly to go to the doctor, but he didn't think it was necessary. After a similar incident, he did go to the doctor and was diagnosed with a TIA. The incident where Gary collapsed was a very serious medical event for him. On Sundays, he and Amanda always slept in much later than the other days. Their routine was not the same every day of the week. They got up much later than usual for their morning coffee. She did make the coffee and went about her morning in the home with the dogs, cleaning, and having a shower. She later found her husband collapsed outside. She is CPR certified and immediately started to care for him by providing CPR and calling 911. She reacted as soon as she saw he was in need of medical attention. Her wrists, which were quite mangled during her accident in 1987, are weak and have little range of motion, but she performed CPR to the point of exhaustion while waiting for paramedics to arrive, something that all of the medical professionals praised her for doing. She was immediately on the phone to Gary's ex-wife and to the children to keep everybody informed as to what was going on, contrary to the recollection recorded in the victim impact statements. Also contrary to those statements, Amanda never withheld from them an opportunity to see their father at the hospital. She was there with him the first day, and as was their mutual friend Jack. But by the second day, she had already been served restraining order paperwork before she even got to the hospital. The only restrictions on the children and the ex-wife seeing Gary would have been by the hospital due to COVID visitor restrictions that were in place at that time. Those who wrote the victim impact statements are looking back upon the entirety of the relationship that the victim and Amanda had with whatever the opposite of rose-colored glasses may be. It appears that they are further victimizing themselves with having these high tempers and they have experienced and apparently nurtured over the past year and a half. Leaning into the idea of being victims of this crime resolves several outstanding issues that the family had been experiencing. And I think it is important for the court to hear these theories and take them into consideration when reviewing the victim impact statements. They were upset, they meaning the whole family was upset about their father dating new women. Well, now the one that he married is gone. Their dad was slowing down because of age and drug experimentation for COVID protocols. He was in pain at the hospital and in delirium. Well, all of that's Amanda's fault. Their family was feeling chaotic and fighting with each other because of Gary dating somebody who wasn't from around here. Well, now they have been unified in their hatred and their bond over vilifying Amanda. This family, in one of the impact statements, states that they have put in the work to heal ourselves, but it just doesn't ring true. Hurt people hurt people. And I believe that when groups of people bond so strongly over negative things, they look back upon the actions of their targeted hate and they begin to see things that were never there and even genuinely believe that some things occurred that never did. For example, one of the victim impact statements claims that Amanda said she feared for her life from her ex-husband of 12 years. That couldn't be farther from the truth. He and Amanda are still good friends and support one another to this day. They share a dog and history and friendship, and that has endured their divorce. The rhetoric from day one from the victim's collapse has been that Amanda is the root of all evil and discord in the family. Never mind that it was the victim who had been openly broadcasting to his friends and family that he was experimenting with protocols of using animal drugs to treat COVID in people. Never mind that the victim had been to the VA and diagnosed with a TIA and pre-existing cardiac issues that he and Amanda combated with regular bike riding and clean eating. Never mind that Amanda is against medication at all, even to manage her own chronic conditions, preferring instead to rely upon diet and exercise. They simply cannot see the good in her before or after Gary's collapse. And what has been Amanda's response through it all? She genuinely still loves them and prays for them and wishes them the best in life. She has attended all of her hearings across the different types of cases that have been brought against her. She complied completely with bail monitoring and worked with the Department of Corrections to successfully complete a year of probation on the restraining order violation case. The restraining order, brought by the victim's son on his behalf, took effect the day after the incident and contained a no contact provision for Amanda and the victim and the members of his family. The only time that was violated, resulting in the aforementioned case and year of probation, was when Amanda sent the victim an email the day she attempted to take her own life due to the stress of the cases and the accusations against her. Prior to that, she had no mental health conditions. Due to her attempt, she was required to attend counseling services, which she did until her provider was satisfied that she had worked through the underlying issues. Also, as a result of the restraining order violation case, Amanda was required to complete domestic violence programming, which she did complete as instructed. Except in the face of her own impending death, only with the intention of saying goodbye, Amanda has not violated the bond conditions of this court, the restraining order conditions, or any of the rules given to her while on probation. The victim impact statements each addressed an alleged violation by Amanda when she moved to a location that was somehow in the proximity of one of the victim's children. This court is well aware of that discussion and that Amanda had relocated to an apartment in Madison and was working full-time in Madison, a very large city. Her probation officer received a complaint from the victim that he thought Amanda's address was too close to the address of his daughter. When asked about this, Amanda stated that the last known address that she knew of for that daughter was in Madison, but quite a ways away from her, and the population density of the city meant that they had had no incidental contact or issues in the several months that she had been living in Madison. Apart from the email she sent when she thought she was dying, Amanda has not sought any contact with Gary or his children or his ex-wife in the past year and a half. Amanda has demonstrated for a year and a half that she is capable and willing to be compliant to the wishes of the DOC, even when it is detrimental to her immediate needs. For example, when her probation agent interpreted the no contact to mean that Amanda was living too closely to Gary's daughter's residence in Madison, she only gave her 2 days to vacate her apartment. Amanda left immediately without knowing when she would be able to go back for her things or where she was going to live. Amanda is the kind of person who leaves a good impression on everyone she meets, including landlords over the years. During this period of homelessness and displacement, Amanda's landlady in Madison let her come stay on her couch for a month. Amanda has now seen the utility of that point in her life, as it has shown her that her purpose, for now, is to help people who experience homelessness. In her free time, she has been volunteering with 2 groups in Madison who help the unhoused in their time of need. It is our request of this court to allow Amanda to remain in the community and to place her on any length of probation that this court deems appropriate. We have absolute faith in Amanda's ability to continue to be successful on probation again and to be a productive member of society while under supervision and beyond. I believe that Amanda was released from counseling services too quickly after her attempt on her life, and I believe it would be in her best interest to be required to continue with counseling services during the course of her probation. It is the least restrictive environment in which the state can achieve the goal of making sure that Amanda is rehabilitated, the public is protected, and it does not unduly depreciate the gravity of this offense. To be clear, despite what was proclaimed relentlessly in the victim impact statements, the offense here is first-degree recklessly endangering safety. This is not an attempted homicide case. This is a woman who pled in to recklessly endangering the life of the victim. We recognize that charge is serious, but it does not have a minimum period of incarceration, and that is for a reason. It is because legislature believes that there are circumstances in which it is possible for someone to have been found guilty on this charge, but not necessarily need a period of incarceration to achieve the goals of sentencing. We believe those circumstances are at play here. We have a woman in her 50s with 0 criminal history outside of the email she sent, which was a violation of the restraining order. We have a woman who has lived a pro-social life. She works, she is God-fearing, she's a productive member of society and has been doing that for 5 decades. She is a woman who works in positions of service to others, who volunteers with her church and at homeless shelters in her free time. A woman who has maintained her faith and forgiven those who have trespassed against her in the telling of their stories since this case began. If this court ultimately decides that the screams of the victim and his family for a period of incarceration cannot be ignored, we pray that this court consider the option of having 1 year of conditional jail time be a part of this sentence. This would allow Amanda to remain in the community with her spiritual leader and congregation. The leader and members of the congregation are here to support her today. To allow her to continue to serve others through her employment and volunteer activities rather than cost the state money for incarceration, and to allow her to keep working with the mental health provider she started with and who she can hopefully continue to work with once she is no longer under supervision. She could also work on saving money to replenish what was lost in the divorce and on legal fees, to eliminate any concerns that the PSI stated about housing security or finances. She could participate in anger management programming to eliminate the only other area the PSI identified as clearly needing work. Amanda is a soft-spoken and deeply feeling person who will accept the will of this court as the will of God, and thanks this court for the opportunity to have had this PSI and for the time that we have had in front of the court today. Thank you.
Judge, could I rejoin for a second?
Go ahead.
Thank you. And certainly, if counsel wants to respond, obviously that can happen. I just have to point it out that this is the alternative version of reality that I caution the court against. What was presented largely in that argument was essentially the defendant's belief that this entire case is the result of a conspiracy against her, that the victim and the victim's family have conspired to make everyone believe that she is guilty of this crime. It's simply put, it's victim blaming, is what it is. I think that's the clearest term I can come up for it. The statements about the victim's children were always upset anytime the victim dated anybody else, and now they've got what they wanted. They've divorced. The victim and the defendant are done. Comments about they're victimizing themselves. Comments that they made false claims that they're claiming this was a bond violation. I don't know that anybody claimed it was a bond violation. I don't think it's accurate to say that one of the victim's children who said he did notice his dad appeared slow and lethargic during a round of golf was an acknowledgement that he's just getting older, he's slowing down because of his age. That's not how it is written in this PSI. That's not the statement that was submitted to the court. I think that's an inaccurate rendition, an interpretation of that victim impact statement. What is clear is that the victim and the victim's family are angry and they are hurt, and that there's a lot for them to deal with here, a lot for them to unpack. And in part, because as we sit here, not once have we heard, and this is what the PSI points out at the end, not once have we heard the defendant take accountability for her behavior, not once have we heard the defendant express any kind of remorse for her actions. And so this is a family and a victim that are rightfully upset, because the facts that we've all agreed to, as alleged in the criminal complaint, are that the defendant poisoned the victim. What her purpose was, to see the victim die, to see him incapacitated, to see him in a coma. I guess I'm not going to completely venture a guess, but the truth remains, regardless of the reason for the poisoning, the defendant poisoned the victim. She left him alone for the poison to set in. She showed utter disregard for his life. She gave him euthanasia drugs and barbiturates, not something the defendant was, or the victim was supposedly self-medicating with or experimenting with, something that she introduced into his system. That's what we're here for. That's the version of facts that we have to focus on. So I appreciate Judge Yu for letting me rejoin. I just wanted to address that alternative version of facts. Thank you.
And Ms. Chapin, is there anything that you want to tell the court at this time?
Sure, good afternoon, Your Good afternoon, Your Honor. Good afternoon, Your Honor. As I appear before you in this court today, I reflect on the past few days and weeks and months that I've been asked the question by many, are you ready for whatever decision the court may rule? Your Honor, honestly, I'm not. But what I am ready for is to continue walking out my faith in God. I do believe and have believed from day one that by His grace, He will see me through. Today, I stand before you stronger, and I give all thanks and glory to God for his grace, to my mom and dad for their love, morals, and strong faith that they embedded in me as a child and adult, though they are no longer here with us. To my siblings for their love, support, faith, and believing in my strength to persevere on days I felt I just couldn't go another mile. To my church and faith family who has stood by me with open arms through it all, constantly reminding me to keep my faith in God's love and grace. And for the many beautiful souls I've met along this journey, this past year and a half. I've seen the face of God, Your Honor, through turning my pain into my passion, my misery into my ministry, while volunteering at the homeless shelters. Instead of asking myself why this has happened, I tell myself, why did this happen for me? Life is truly about a journey and not the destination. I will continue walking out my faith in God and serving and advocating for my unhoused brothers and sisters. Your Honor, hate has created many problems in our world today, but has not solved one yet. With that said, whatever this court rules today, I will continue to stand strong in my faith and God's grace, along with my own anthem I've had throughout my years. I did not come to teach you. I came to love you. It is my hope that love will teach you. Thank you.
Okay, thank you. And now it comes the difficult task that this court has in fashioning a sentence that is appropriate in this case. To do that, I have to look at something that is individualized to you, Ms. Chapin, taking into consideration what is the general threat that you pose, also taking into consideration the seriousness of the offense and any needs that you may have. And any sentence that I fashion needs to be the least restrictive, taking into consideration those things that I've talked about. And I always start out this conversation by looking at the offense as I understand it. The crime, endangering the safety of others, goes to basically the core concern that society has. We want to make sure that people are safe, especially in their homes and with their family. In this case, the victim ended up in a comatose state because he had a large amount of barbiturates in his system. He was not prescribed any of those barbiturates, and one of them is a drug that is primarily used to euthanize animals. The victim's son was able to tell law enforcement where they could find these drugs in the home because of the probably pattern of what had happened, including the euthanasia drug, I think, being able to be found in in his truck in a lockbox, because that's where it would have been. And as I read through the criminal complaint, the PSI, and the various things that I've read, it indicates that these issues with the victim started in July, when he started having some balance issues, suffering from vertigo-like symptoms. But then, as I indicated, it ended up with him being at the VA hospital in that coma. This case has taken a toll on GC and his children. The public nature of a criminal trial is not something that anyone wants to go through. And GC just wants this chapter in his life over. GC has written both to the PSI writer as well as to the statements to this court about the effect that this incident has had on his health. For a year following the offense, he noted that there was concern that he might have permanent heart damage. Luckily, that has been resolved through exercise and working with his cardiologist. GC has continued ongoing problems with parts of his body that stem from him having to be put in restraints while in the hospital for his own protection after he woke up from that coma. He's afraid that those injuries may never be fully healed. GC's children, from what I can understand, had suspicions about you from the beginning, and you can see that throughout the criminal complaint in the PSI report and also the statements that they have made to this court. Regardless of their feelings towards you, and you've indicated that there might have been some other issues or some other events that were more positive, regardless of any of that, they were incredibly traumatized by seeing their father in the hospital, having limited access because of the COVID restrictions, and then also seeing him in the aftermath of that recovery. One of his daughters had to fly here from Washington, and when she got packed, she decided she better bring something in black because everyone was saying, we're not sure that your dad is going to make it. JC's ex-wife was also able to describe the effects that this had on the children that she shares with him. Watching him wake up from the coma and the psychological effects that it had on him, that is something that will be with them forever. And their life has been changed forever because of that. I note for the record that this is a circumstantial case, but circumstantial cases can be just as good as cases with direct facts. The circumstances are based upon the timing between GC drinking the coffee and the symptoms that he had. Time between his last memory and when you called 911. Changes in his power of healthcare attorney, home ownership, a hurried marriage looking for financial independence, the missing mortar and pestle from the residence, your internet searches, and I've heard more information about that in terms of looking for flights and looking for property, and then also the suicide attempt that you made. That is one of the factors that when looking at the jury instructions, that is something that might have come in, showing a consciousness of guilt. You continue to profess your innocence, but you also realize that the state could have proved you guilty through those circumstantial cases, so circumstantial issues. GC feels very strongly that you meticulously planned to poison him. As he put it, you practiced on him twice. And that leaves me, though, with the sentencing you on the first degree recklessly endangering safety. As I look at that, the potential is a 12.5-year sentence, and that is something that in the legislature's mind is serious because of the nature and the length of the sentence that is there. I would agree with your attorney that it doesn't have a mandatory minimum, but first-degree intentional homicide also doesn't have a mandatory minimum when it comes to sentencing. So there are certain issues that the court may take, or that the legislature takes into consideration, and just because they don't have a mandatory minimum doesn't mean that it's not a serious offense. So I now turn to what I know about you. And if I've done my math right, you are 51 years old. You were born and raised in Trinidad, one of 5 children. Intact family, where your mother involved in politics and your father farmed. You describe your parents as having a strong faith, instilling that strong faith in you, and teaching you to give back to your community. You indicate that you were blessed to have such good parents, and that you've indicated that as well today in your statement to me, and that your parents unfortunately are deceased, but they are still with you, and have still been able to provide guidance for you. You have siblings, 3 sisters and a brother, all very supportive of you. You have weekly video calls with them and daily chats with them. You've been married 3 times, each one ending in divorce, but you've indicated that you're on good terms with your second husband who lives in Illinois, and we did have that bond modification to allow you to travel there. You attended school in Trinidad, and with the difficulty in getting your records from there, when you moved to the U.S., you did get your GED just to be on the safe side, to say that you actually had that. You report that you were a good student, and your schooling in Trinidad was cut short because of the automobile accident that you were in and that you've talked about. You immigrated to the United States in 1991 and became a citizen about 20 years after that. You lived in New Jersey, Florida, Illinois, and now in Wisconsin. Your employment history, primarily in the social services and healthcare positions, and those helping sort of jobs. Starting out as a social worker, then moving into group home management before becoming a program manager and healthcare coordinator. Most recently, you've been working in positions as a care worker. Wanting more flexible hours, you also pursued training to become a yoga instructor. You have ongoing health issues as well that you seem to be managing, and no specific mental health diagnosis, which I do agree with your attorney is unfortunate given the attempt that you made after this occurred. No criminal record to speak of. Most related, well, your criminal record in Wisconsin is clearly related to this situation and involved that restraining order violation. You've done well on probation. In fact, you successfully completed it, completing the domestic violence training that was required of you. You did have GPS monitoring at one point and had that requirement to change residence but you did follow through with that. And according to the Lafayette County Sheriff's Department, you've also been compliant with your bail monitoring program here. The PSI writer was also able to find a domestic violence related charge in New Jersey. It was dismissed, and you explained to her that at the time you were defending yourself against a boyfriend who had come at you. You ended up tearing his clothing, and it was dismissed against you because of the total nature of it. I would note as well that you've been cooperative throughout this process. And while you continue to maintain your innocence, you also do not express any feelings of anger towards the victim or his family. And given the general nature of people, that strikes me as a little odd. You've been able to explain some of it from your standpoint and your viewpoint in terms of what that means to you, in terms of the power of forgiveness. Also, in looking at the PSI writer in the compass evaluation, I thought it was very interesting that the compass evaluation lists a history of violence as medium risk, and then some personality traits as either probable or, in the case of anger, highly probable of future risk and needs for rehabilitation. And those are things as well that I look at. I can't base everything on it, what I do, but I do find that to be interesting in my review of the PSI. So, as I indicated at the start, I need to do the sentence that is the least restrictive. And that least restrictive idea is the idea of probation. However, in reviewing this case, I do not believe that probation is appropriate. And the reason for it is it would unduly depreciate the seriousness of this specific offense. Mr. Chapin almost died. He has had substantial health issues as a result of what occurred. And his children have been traumatized by seeing their father in a coma. By placing you on probation, I believe that that would unduly depreciate the seriousness of this offense. So, I then need to look at the reasons that I do sentencing, and that has to do with your risk level. What is that? And as I indicated, there are some issues having to do with the anger and the personality traits outlined in the compass that could use some assistance. Also, I need to look at the idea of that rehabilitation, because if you can address some of those, then your risk level is much, much lower. But then I also need to look at the punitive component, and that is one of the factors that the court also needs to consider. And since I've kind of talked about it when I said, is probation appropriate, and not thinking that probation is appropriate. As I've indicated, the victim almost died. He has continued health issues. that idea of feeling safe in your own home or trusting other people. And also, you do put yourself in the positions of caring for older people, and there's some things that also concern me with that. And the court needs to look at that issue of punishment as well. And I believe that what I'm going to do will take into consideration a punitive component as well as the rehabilitative work that needs to be addressed. And so for that reason, I am going to sentence you as follows to the Wisconsin State Prison System. I am going to sentence you to a total of 6 years, and that will be 3 years of initial confinement and 3 years of extended supervision. Conditions of extended supervision are no contact directly or indirectly with the victim, his residents, or his family without prior agent approval. I also need to order a DNA sample to be taken. I don't believe that has happened. I don't believe there's very much sentence credit to speak of at this point. Costs and fines will be covered and carried out through the bond that was posted, as well as I believe I can use that to cover the remainder of your attorney's fees. I'd note for the record that you have been paying. As I said at the beginning, this is a hard job and hard role for the court. I need to do what is the least restrictive. That is what the law tells me. I also know that when I get done, that I never make anyone happy. But that's not my job. My job is to individualize the sentence to you based upon that least restrictive component. And so in doing so, I believe I have accomplished those goals of being the least restrictive, taking into consideration that punitive component that is needed as well as the rehabilitative work. Any questions, Ms. Frudiger?
No, Judge.
Okay, any questions, Ms. Johanning?
Yes, would she be ERP eligible, Your Honor?
She's not ERP eligible because of her age.
What am I trying to think of?
Substance abuse. I don't think she's got a substance abuse issue.
There's challenge, correct, there's challenge incarceration.
Challenge
substance
incarceration is what we used to call ERP, I believe. She's not eligible for that because of her age. She's statutorily eligible for substance abuse programming, but she doesn't have any
Right,
she doesn't have any substance abuse issues, so.
right, thank you, Your Honor.
A sentence credit is 2 or
Judge, I apologize, I don't have that number
just a second.
in front of me.
She signed the cash bond on, she signed a cash bond on February 20th, 2023.
I think her original bond was posted on January 27th. So I have her in custody from January 4th through the 27th.
23 days.
And then I have, correct, that would be 23 days. And then I have